The states say you can't drive a truck unless you're 16, unless you're over 21.
I think the states could have.
Oh, so that's not with respect to the motor vehicle. It's with respect to the driver who's going to drive it. Can the states say truck drivers have to wear seatbelts?
That would be compatible with federal law, Your Honor, and they could do that.
All right. So what's incompatible with federal law with respect to safety to say you shouldn't operate this if you're a careless, negligent driver?
The states can say that. What they can't say is that a broker can be held liable.
Why not? Because the broker's one putting the driver in the seat.
That's not correct, Your Honor.
Of the motor vehicle that's causing the accident.
That's not correct, Your Honor. That's another real, I would say, not accurate depiction in the briefing here.
Wait a minute.
Yes.
The broker hires the company who's going to transport, says the company is negligent because it's had, I think, 2 or 3 accidents in the space of a month. Drivers have, and it only has 9 trucks. And it has a driver who just that month had another crash where he was found negligent. I don't see how someone hasn't failed in their duty.
Yes, Your Honor, that would be the carrier and the driver. The broker doesn't know all that.
Well, then that's a defense, counsel.
Yeah, it is a defense, and it's also why there needs to be.
But it's not. It doesn't answer the substantive question of whether it could be held liable if it had a way to check.
If it was required to check this special checking system, and I go back to Roe, where this court said that the main statute there that would have required the carriers to check to see if the packages were going to be directed to a minor shipping tobacco, that would have imposed this patchwork and would have imposed this extra duty on the services of the carriers. And so
safety regulations always create a patchwork. No matter what the safety issue is, there's going to be different state requirements, and so the patchwork exists as just because of the exception.
But can I address that, Your Honor? Because Section 31141, which both parties cite, seeks to eliminate that. It gives the Secretary a pretty broad power to preempt after decision. So while the states can enact their own safety regulations, they must be compatible with federal law, consistent with federal law, even if they're stricter. And if they burden interstate commerce because they create a patchwork, and we're talking about driving through multiple states. Here it was Ohio, Texas, and Arkansas, I think. And so you need to have the certainty that you can traverse those jurisdictions lawfully.